So hello everybody, I'm Paul Clark from SpallClark Solicitors. So today we go through a presentation just about planning for the future and moving forwards. So one thing I want everyone to remember or take away from today is that you're not alone. There is support available. So a bit about us. So we're what we call a specialist private client law firm. So we deal with complex matters such as wills, powers of attorney, court protections, and that's all we deal with as a business. We offer fixed fees for most of our work wherever possible, just so there's that transparency and everyone knows what the cost will be before we do anything for them. We don't charge for meetings, initial meetings. We're based in Congleton in Cheshire. We can meet at the office, we can meet at your home. We can also meet online by Teams as well. There's no extra cost involved for that. This bit about me. So that's me and Asher. We're both just a bit greyer since then, since those pictures are taken. So I'm a solicitor. I'm part of the Law Society Private Client Section Advisory Committee. Bit of a mouthful. Essentially, that means I help support other solicitors as well with training events. We have a magazine that goes out to raise issues that's a topic as well. And some client advice. I'm a member of STEP, which is a worldwide organisation for solicitors in this area of work. Previously volunteered at a hospice as a legacy officer and former trustee of a charity that supported adults with learning disabilities as well, many years ago. So what we go through today is 3 topics. Starting with what planning to be put in place first, the planning for the future, support following death of parents, and then moving forward in the future as well. So the first part is what plans to be put in place to protect children. So really the importance of planning is about stability. So for example, if somebody is receiving state benefits, an inheritance can cause a loss of those benefits, and lose stability, and can cause lots of upsets, disruption as well. So keeping stability is really important when you think about planning. It also gives control as well. So control about what's going to happen, who inherits and when. It's possible to protect the inheritance as well, and that links back to managing benefits, those sorts of matters. And most importantly, it gives peace of mind. Peace of mind to know that everything is taken care of and what we want to happen will happen. So what is a will? Well, in simple terms, it sets out who should inherit when someone dies. You can make important decisions, such as if a child is under 18, appointing guardians. You can also include wishes, such as funeral wishes, which we touched upon earlier as well, and also guidance as well, if there's a trust in place. In avoiding intestacy rules, so rather than setting out what you want to happen, the intestacy rules are set out by law about who should inherit, and it goes to certain family members. So by having a will, you avoid that. You decide who inherits and when. For example, inheritance can be delayed or it can be ring-fenced and protected for the future. Appoint executors to carry out the instructions in the will, and then the trustees as well. So if there's a trust, the trustees can actually manage those funds for the future. And if there is a child, then appoint guardians too. The executor's role is to carry out the instructions. It's not to change what the instructions or wishes are. The job is to identify and value assets, so that could be a house, could be bank accounts, personal possessions. If there is inheritance tax to pay or other tax, you can deal with that as part of the process. Pay any money that's owed, credit cards, mortgages, and then distribute either to an individual or into a trust. Now, who can actually become an executor? That's an important decision, I think, particularly if we have vulnerable people as well. So family and friends, first port of call for many people, they can act. Professionals can act as well. And the key part is really workload. It's quite known as task being an executor. So if someone's dealing with grief, if they're working full time or caring for somebody, it's an extra burden on them. So some people feel that actually taking a step back and appointing a professional to act takes that pressure off. So that's really factored into that decision. Guardianship only applies if the child is under 18. It will take effect on the death of the person with parental responsibility. So if there's one parent, it would be them. If there are 2, it would be the death of the survivor. If there are no wishes or no appointed guardians, it's the court who will decide. And importantly, you can set out a list of wishes in terms of what should actually happen, in terms of what should happen with the guardianship and what the child likes and dislikes. When planning with the will, you can include a trust. So a trust is set up upon death and is designed to protect the inheritance and to choose people to actually manage that inheritance, and they're called trustees. And there are many different types of trust. Particularly popular types are what we call a discretionary trust, where instead of saying it goes to this person, you then group of people, and the trustees then choose which person should inherit, when they should inherit, in accordance with any wishes that are left as well. And it's possible to have what we call a stable bundle persons trust, and that really changes the tax treatment more than anything else. There's certain criteria to qualify for as well. And the key decision really is the trustee, who should actually manage the funds. And again, similar to executors, it can be an individual, it can be a profession, or people we trust, such as family or friends. Moving on, so once a planning is in place, is what support is made whilst the death of parent. So how do we come through that process? So initial steps are notifying relevant authorities, registering the death, and at that point, the registrar would ask about service called Tell Us Once, and that's an organisational service that notifies government organisations, EBLA for example, Passport Office. Arranging a funeral, obviously very important. We heard a bit earlier as well about what to consider. And securing the property, which often that does get forgotten about, so it's making sure that the insurance is in place if there is a house, making sure it is fully secured. There's emotional and practical support available as well at that time. Particularly losing parent, it's a very traumatic life event. Friends and family can be there to provide support, but there's also charities, the Good Grief Trust, for example, local support groups, which we've heard from today. GP may be able to make recommendations. Funeral directors also offer a lot of support at that time, just guiding through that process, initial steps. Sometimes it could be bereavement benefits. Local law centre or Citizen Advice Bureau can actually provide advice about that. And then during the legal process itself, solicitors provide support. So we support people and guide them through the process from the very beginning all the way through as well, which can help take the pressure away. So in terms of what probate actually is and what it actually does. So it's actually the legal right to deal with a person's estate. So that could be a property, so it could be a house, personal possessions, their money as well. It's known as their estate, is the word we would use. And the first step is to really understand if it's actually required in the first place. So if there's a will, the executors would apply. And if there isn't a will, it's the person or people entitled under the intestacy rules, which is why it's so important to actually have a will in place in the first place. Simply because if it's the person that's going to inherit, they may not be able to deal with this or may not want to as well. If there's a will, the executors must decide if they want to act or can act. For example, they can step down, they can appoint somebody else to act as their attorney for them. And they've got to be satisfied that it actually is the last will. There isn't actually a later will that's been made as well. It's got to be signed correctly with 2 witnesses. And then take the immediate steps, which usually will be identifying the funeral wishes, if they're in actually the will itself, or what we also recommend is a letter of wishes. Then can be updated and changed. So just a bit more about the role of executors and trustees, because they're a similar job, but they are different, and they often are actually the same people. So the executor's job is to carry out the administration of the estate. So collect together what there is, identify what there is, pay tax if there is any due, and most people don't pay inheritance tax. So maybe out there in the media, it's a very limited number of people that actually do pay. And then distribute the estate in accordance with the terms of the will. So that would either be to an individual, or if there's a trust, to the trustees. And the trustees will then manage the assets in the trust in accordance with the rules of the will. That becomes what we call a trustee. And it's got to act in the best interest of beneficiaries, so they can't just go off and do what they want. There are some obligations they have to comply with. If there's no will, Then the first step is to actually identify who is responsible for dealing with the estate, and that's which family member it actually is. And there's a set of rules about where it flows down to which branch of the family. The terminology changes slightly, so they're an administrator rather than an executor, although their duties are actually very similar to what an executor would actually do. And then it's distributed as per the intestacy rules. There is professional support available, even if you're an executor or person entitled, and solicitors can act. As a rough guide, the two main services offered are what we'd call grant only, which is where we would do the initial legal work. So that would be applying for probate itself. The executor does everything else. Or we can just do everything from start to finish. So sometimes we get a box of papers through and say, can you deal with this? And we just take care of everything. So family or people can just deal with focusing on what's happened, rather than actually worrying about the legal side of things. Once the legal side of it's complete, it's really then moving forwards to the future. And the two main parts, and I would say that getting started after a bereavement, and then planning for the future as well without parents. So what we've often found is the key part is actually putting a system in place. So creating a decision-making tree. So if somebody has received an inheritance and people around them know that they have, say if a friend asks to borrow some money, how do you make that decision? So it's that decision-making process of what to do in that scenario, and also what to do if you need support. So I'm not sure about making a decision, who do I speak to? That's going to be different in every case. It could be a solicitor, it could be an attorney, it could be something else. So friends and family, through choice, some charities actually help just having a discussion about this is happening, what do I do? Supportive organisations, and also professionals, whether it's a doctor, a solicitor, somebody else. It depends on the decision itself that needs to be made. But the key really is knowing who to turn to. In this scenario, who do I speak to? Then planning for the future, which is making a will and making a power of attorney. Making wills, making wishes count, whatever those wishes are. In terms of how to make a will, they can be made individually, don't have to see a solicitor or professional. Generally, a solicitor would be involved and they would guide everyone through the process. Who can make a will? Well, anyone can make a will as long as they're over 18. Just because somebody has a disability in some way, they can still make a will. And if they can't, then there's still a process in place. So if they didn't meet the legal requirements to make a will, then there's a court process. It's called a statutory will, but essentially applies to court, say why it's important, why that person can't make a will, and then the court puts in place the will to meet their wishes. Power of attorney, I'm sure many people here may be familiar with it. If anyone's not, then there's two types. Health and welfare, which deals with where somebody should live, medical treatments, licensing treatment, and property and finances, and that's paying bills, dealing with the house if there is one, making financial decisions. And it's about appointing someone to help the individual make decisions for themselves. It's not taking over, it's not taking control, it's helping support someone to make their own decisions. Only if they can't, that's when the attorney steps in and makes the decision. And it's also possible to make or give instructions about things that are considered important, and that's different for everybody. Example could be if they wanted to receive care at home rather than going to residential care. It could be about religious beliefs. This is something really important to somebody, and they can put that instruction in. Then all decisions have to be made in accordance with that. Or it could be things like ethical investments. If somebody did receive large inheritance, didn't want to invest in things that support the arms trade, for example, that can go in. And you can also have preferences, which are wishes. So I like this, I don't like that. And that gives guidance for the attorneys when making decisions. So as I said, the key is the attorney is there to provide support. It's not taking over, it's providing support. They will make decisions or can make decisions if the person can't. It's about providing that stability and making sure bills are paid, finances are managed, and then making decisions about medical treatments, lifestyle treatments, care decisions, where someone should live, and day-to-day decisions like that as well. Can be family and friends appointed as attorneys, And again, similar to an executor, workload should be factored in as well. So there can be lots of decisions that need to be made. Professionals can be appointed to, so we act as professional attorneys for people on occasion. Works very well, we do it on a regular basis, but we do charge. And that should be factored in, and if a solicitor was appointed, they would factor in any financial aspect too, because there's also no point appointing a professional if all the money is just going to be spent on legal fees. So we wouldn't act in that scenario. Attorneys are under legal duty, and they've always got to act in the best interest of the person. They've got to try and support someone make their own decisions, as mentioned before, and try and act in a way that's not restrictive. So they can't just come in and take over or take away any freedom. So for example, if somebody is living at home, they need support. It's about how is that support provided. It's not the case that they need support, therefore they have to go into full-time residential care. It's how can we provide care, what support is there, how can we let that person live in their own home, or if they needed to go out but needed support when they're out, how is that achieved? It's not the case of just locking someone away. And they can't mix their own funds with the person's funds either. They've got to be kept entirely separate, and you can't make the person gain. That's really important as well. And they're under very strict duty of care set out in the law as well. So in terms of a decision-making tree for an attorney, first step is to always check the instructional preferences before making decisions. So do you actually have the authority to make that decision, or is there any guidance for them for making that decision? They then provide the support in making decisions, so speak to the person and say, well, what do you want to do? And any major decisions should be discussed with professional advisors. So if there's money to invest, you should take financial advice as well. You shouldn't just put it all into a bank account. You should actually receive advice if it's required. And if there's a co-attorney, discuss it with the co-attorney as well. Even if they've got the power to make decisions individually, it should be discussed and agreed what's actually going to happen. It can cause difficulties otherwise. So, similar to a will, you need to have what's called mental capacity to make a power of attorney. The bar's a bit lower compared to making a will. You still need to have that, and there's a presumption of capacity. So it's assumed that people do have the ability to make power of attorney unless it's established that they cannot do so. And a person with disabilities can make a power of attorney, you're not automatically excluded from it. So whether that's a diagnosis of dementia or any similar conditions, whether it's someone who has a learning disability, it doesn't automatically exclude somebody from actually being able to make a power of attorney. That's really important. In a scenario where someone doesn't meet the requirements, there is a process available, and it's called a court of protection deputyship. Essentially, it's applying to court to say why this person should be appointed a deputy, similar to an attorney, and then a judge will decide ultimately. So there's a loss of control in comparison, relying on a third party, but what they would receive is information about the person. So what's their financial position, who's involved in their daily life, who comes to visit them, what cares do they require. The problem with the court of protection application is it's very expensive. So generally it's in the thousands in terms of costs, and it's very time consuming. So it takes over a year at the moment to actually put the order in place. And the administrative burden is quite high. So every year a report needs to be submitted to the Office of the Public Guardian, who oversee the deputyship order, to account for all spending. And you should ideally keep a set of accounts, say what's been spent, record of decisions been made, why you've done this, why you've done that. So it can be quite onerous in comparison to a power of attorney. Professional advice. So when it comes to planning for the future, taking professional advice about wills and power of attorney is important. So solicitors can assess capacities. It's a legal test rather than a medical test, where they overlap a bit. We provide advice about options, so what's available in terms of a will or powers of attorney, what instructions should be put in, what do other people do in similar situations, what's important to them. And that can help provide guidance. So people are thinking about, well, what do I want to put in, what's really important? But we can help find some options. And most importantly, solicitors are under a duty to ensure documents and advice are actually correct. So the problem with powers of attorney is they go to the Office of Public Guardian for registration, and they're rejected because the instructions are workable or something's been missed, whereas we're under duty to actually make sure it's right first time as well. And the advice is right as well. So that's everything from the beginning to moving forwards. And as I said before, the key part is there is support available. So people aren't alone. There is support at different stages, professional support, friends and family, and organisations as well. So have you taken any questions, or I'm also here just to answer anything if people want to approach privately as well.
Brilliant, thank you very much. I know we've got questions.
Yeah. Could I just ask you, because you said there that solicitors can assess capacity. So can you tell us how you would just assess capacity?
Yeah, it's a different test for a will to power of attorney, so it's set out slightly differently. Say, for example, with making power of attorney, what we'd normally look at is, it depends, what we'd review initially is, does anyone have any diagnosis which could affect the ability to weigh things up? And then it's about looking at how they communicate their decision as well, and understanding. And actually it's trying to get onto that level then of actually understanding how best to communicate with that person. So sometimes we have people that, or we had someone recently actually that lost power of speech, but they couldn't talk. So it's that, how do we communicate with them? How can they communicate with us and understand? And really the key for power of attorney is understanding what it actually does as a document, in terms of, if you sign this, an attorney will make decisions for you, what powers they have. So it's going through that at a level that somebody would understand. And we have to be satisfied that they do understand the power they're giving away, what it actually does. And it's different for everybody in how we communicate that. With the wills, there's a very specific test, which is understanding what assets somebody has. Do they have a bank account? It's also understanding who there is in terms of the family, or who may be expecting to receive their inheritance. So there's certain tests to go through that way. But we try and pitch it towards the individual rather than just a generic broad brush approach.
I think as a parent, we hear that much about capacity and how it's judged. So that's why it's so important, because quite a lot of people with a learning disability, if you said to them, oh, if anything happens, your brother would be like, oh no, he's not making decisions for me. They wouldn't have the capacity to understand why it's important for somebody, because they would think, well, no, I can make those decisions, but we know actually that they can't make those decisions from a financial side of things.
Yeah, absolutely. It's decision specific as well. So it's about trying to work with somebody and get to know someone, understand them, and how they think, almost in many senses, to explain it in a way that actually can understand. If somebody can, not everyone can have capacities to do certain things, but not others. So it's just about getting that level of understanding.
So in the main, you would say that someone with a learning disability in general would be able to set up a lasting power of attorney.
It wouldn't stop someone doing that just because they have that, but it's to the individual. I would say it's different for everybody. So really, for us, it's just being aware, and then it's being able to look at them as a whole, have a chat with them, actually understand what level of understanding, ability to help does that individual have about that specific decision. So I wouldn't say generally do or don't. It's just it doesn't stop someone automatically. So if somebody said to us, my son wants to set up a power of attorney, what I would like him to, has a learning disability, it would be, oh no, definitely not. It would be, let's have a meeting. We don't always wear suits. We dress to however they prefer us to. And colleague Simon very rarely wears a suit. He's always in his jeans anyway. So it's pitching it towards the individual and how we can support that person.
And the understanding that we're here to protect them rather than, we're trying to get the money from them.
Exactly. Not taking over, not taking anything away. It's here to help make things easier day to day. And so sometimes it's as simple as this person pays the bills. It's those sorts of things. It's just getting on that level of understanding to be able to work it.
And am I right that you can't set up a power of attorney until the child is 18?
It's 18, yes, and it's 16 for court protection.
So once they're 18, it is advisable to set up a power of attorney?
I think it is, if they can. I think it is. I think so. Just it gives that extra support, extra protection. So there will be times that won't be able to make certain decisions.
Yeah.
So I would say look at it.
Yeah.
Capacity can fluctuate as well.
And in terms of dealing with the bank, for example, if you've got a power of attorney, can I deal with the bank on behalf of my son? Is that what it gives you?
It depends. It depends is the answer. In the power of attorney itself, there's an option, often finances, of when it should be used. So it can be only if someone hasn't got mental capacity to make decisions. So then that's their judgment. If they're able to make a decision, then no, you can't use it. Or it can be used with their consent.
But it's
So
more
options.
like having a conversation. He would be able to have a conversation with a bank. He might know what he wants to do, but he can't communicate it and be on hold. You know, like you're on hold for
Yeah,
hours
absolutely,
and you're talking to someone in India, and you know the whole thing's quite hard for people without learning difficulties, let alone difficulties.
Yeah.
So yes, that absolutely, it can be used. It's
I
just
mean, do you set up? Do you contact the bank and say, I have now got a power of attorney for my son. His name is X, and I will be dealing with his affairs. Can you put on the system that I am the person that is eligible to speak on his behalf, as well as him? Not that I'm the only person, but you can both. Is that how it sort of works?
So you'll be named on his account. So it should be his account. You'll be there as the attorney of, and they have a team now. Or most banks do it. It's improving a lot.
Yeah.
Where they would have a team that actually deals with it as well.
Okay.
So they should be more familiar with the process and what's actually involved as well. So yes, you can be registered on the account. Yes, you can deal with banking. It's just subject to restrictions.
I mean, that presumably is the major advantage of doing that.
It's the big advantage of doing it. Yeah, absolutely. So I would suggest once it's in place and registered.
Yeah.
Subject to any consent required. Yes, register with the banks. Register with any organisation. Anything to do with any benefits that are received.
Yes.
Everybody really, just so even if you don't need to use it straight away, it's there if you need to.
Yeah, because actually when you need it is when there's a crisis, for example, and you don't want to then not be able to.
You don't want to then start a registration process. It can take a while. So
Okay.
It's the same with health as well. So the health one is.
Yes, because there's two, aren't there?
Yeah,
There's finance
yeah.
and there's health.
yes.
So the health one, you need to take that to the GP, and then that goes on the health records.
And they're becoming tighter on that one as well, where if I've been in with James, they want to, have you got power of attorney?
Yeah.
No, James, it's no way that he would be able to make those decisions or feedback to me what's being discussed
No, exactly.
if I wasn't there with him. So.
That's all right. Is that the only question for me?
Okay.
Can I ask, where there's a diagnosis of dementia, does that automatically preclude someone from having capacity, or again, would it depend?
No, it's someone can have dementia. The
Yeah.
diagnosis of dementia doesn't stop it. It's just something we need to factor in.
Yeah.
So we'll be more cautious, but we certainly look at that and think actually we need to be aware that this person has dementia and factor that in. But no, a person can still make a will or power of attorney with dementia. But of course, with the diagnosis, obviously the earlier the better.
Yeah.
It's more likely that have more capacity earlier in the stage
Sure.
rather than later in the process. No, it wouldn't automatically stop.
So if I wanted to make one for my son, would the advice be to do it by a solicitor rather than doing that? Because you can do it yourself, like an LPA.
Yeah, so technically your son making power of attorney is forcing him with that, but I would personally suggest professional advice.
Because how does someone say he's got capacity?
Yeah, so for will of power of attorney, solicitors would assess capacity for the legal side of it. What we also do in certain situations is we would ask for a medical practitioner as well to provide their view too, particularly because it's not always clear cut with that. It's really making sure the person does understand. So we have an assessment to go through, but sometimes we ask for a medical practitioner to give their view as well. So you'd have two opinions to say, on balance, yes, we believe this person does or does not.
Because that's quite complicated, isn't it?
Mm.
Because to be fair, I'm his whatever I am for all of his new deal benefits, you know. But he's got his own bank account, but I will check his bank account. And if we go to a GP appointment, I will then say to him, do you want me to be here or not? So that's how we work it at the moment. But am I leaving myself wide open there? Do I need to have a legal document that says?
Well, yes. So in terms of the official legal positions, it tends to be different how it works in practice generally. But yeah, officially, if you're using his bank accounts to make payments, you'll be protected by a power of attorney because you're doing that through the legal process of acting as an attorney. So I would say that's the other.
Because I don't make payments, I just check that he's made the right ones effectively. But
Yeah,
But
in the
everything you're
position
doing
of-
is in his best interest.
Yeah.
So you're doing things because it's the right thing for him. You're not taking over. You're not making
No.
decisions on his behalf.
and he's relatively, calm. He did make those decisions. He knows what he's paying for, what
Yeah.
he's not paying for.
So you're supporting him
Yeah.
to make those
But I
decisions.
feel like I could be left my why doesn't it? Not got a document. So. And
Well,
then
no.
how does he then decide that I am okay to do it?
It's also the convenience, because as just mentioned, if you've got something you have to deal with the bank with, and it's quite a complex thing. I know James wouldn't be able to deal with
Yeah,
that, but I wouldn't be able to for him without the lasting power of attorney, because I'm not the accountant.
And then the other thing you need to think about is obviously your mum. So, you know, what if you weren't here tomorrow?
Yeah,
Then who's going to be
Then
dealing
who
with it
would?
all?
yeah.
Yeah, and you can appoint replacements in the power of attorney as well. So so if you're named as the attorney, something happened to you, the backup would then step in to then find that support as well. So it's really making sure there's always somebody there to help. And there may be times when something happens where you get a bit stuck and you need the power of attorney. Having it in place means it's just there straight away.
And
Takes about-
you know who it is that's going to be dealing with those
Yeah.
finances in the future and things.
But until you've got one in place, you're okay. But it's good.
Right.
It's better to have that in
Yeah.
place.
Okay.
Another thing to think about.
It's
Yes.
just like another layer, isn't it, to
Mhm.
go through?
Yeah.
And then we've got to go and see a solicitor, and then you may say it needs a doctor's thing to say, Jesus Christ, you know, come on. All we want is to protect him. We're all out to protect him. But we're going to go through
Yeah.
3 or 4 loopholes
Yeah, you
Yeah.
do.
before we get there
There you go.
with
you
yet
do.
another one.
On the plus side, once it's done, it's done. It's
But
in
it isn't,
place.
because then you have to be nominated if I clerk it and
Oh, well,
else
yeah.
got
You
to
do all
do
that
it.
at the same time.
You do it at the same time.
But yeah, but then who do we put? You know, if it's me and Dad.
The conversation we were having the
You
other
know,
day.
where do you go?
Yeah.
Because you don't know, do you? Really, what's going to happen?
But what happens in some cases is, with a client of mine, is very similar, where it's his mum and dad. Who else is there? There isn't anyone. In that case, they appointed a professional. What we've done is that we've then had meetings, so we're introduced, so that she, in this case, she knows us. She knows me, because I'll be her attorney if anything happens to mum and dad. So if something does happen, it's not just this stranger coming in. It's this is Paul. He came to the barbecue last Saturday, and it makes it a bit easier. So professionals are an option, but I would say get that familiarity going as well. So it's not just a stranger coming in. So that's an
And if
option.
you left your current company, you would
Yeah.
still be the attorney. So
Yes,
it's
a
a
personal
lifelong.
appointment. It is. It's a personal appointment. That is it. Yeah. So even for a time, it's still be.
Yeah.
I think as well, one of the difficulties that you have when you've got someone with a disability in the family is that quite a lot of families are very isolated, you know, because of that. So you might have family that you would appoint as attorneys, which doesn't necessarily mean they live close by or they can. So is there a step between having an attorney and, because that's the other thing that as this organisation would like to do, is to take on some of that role, advisory role from finance and things like that. So would they only be able to do that if they were listed as an attorney?
Officially as an attorney, yeah. Doesn't stop the general advice around the edge to advising whoever is the attorney, but yes, officially it'd be the attorneys who make the decisions.
So Barry and I spoke about that the other day, that, you know, I could be that stepping stone between Hannah and her power of attorney.
Yeah.
And that's where all the support groups come in and the advice.
Yeah.
Is the attorney's not alone. That's the key really. They're not just left to it. There is support around the edge, even though they officially have to make the decision.
Barry's had his hand up for a
Yes.
while.
It's okay. I'm pondering.
Do they have to be a British citizen if I named them, because all my family is abroad and far away? But do they have to be a British citizen?
Don't have to be. It helps if they're in the UK, because it can be banking issues sometimes. Some banks are okay, but sometimes if an attorney is based abroad, there can be issues about actually accessing the accounts. It's just to do with their anti-money laundering regulations. So it depends on the bank, but we've had situations where we do actually check with the bank. We do say double check if you're appointing this person, just to make sure there won't be any issues. Have come back before and said actually, because it's country located, we can't put banking facilities when someone's from that particular country in this case. So in theory, it doesn't stop anything. It's just extra checks to go through, make sure there won't be any banking issues, for example. Practical day-to-day issues, how can we make decisions? If something urgent needs to be done, how can we do that?
And the will as well, the executors and the trustees,
it's okay.
It works in the same way, yeah. It's absolutely fine to do that. It's just practical difficulties just to consider and address at the time that are being appointed. Often, if it's an executive, they'd appoint solicitors to their part. So they'll still view and approve things, but day-to-day solicitors would deal with it. So it's really just being extra aware, I suppose, and addressing any potential issues at the time it's made. If there is an issue, choose somebody else. But in itself, it wouldn't preclude something.
Okay.
Right,
Yeah.
we're ready.
Okay.
Finally.
Just following on, which is why I was pondering from what you were talking about. My daughter's finances, she has a bank account, and I monitor it with her. Well, I do the work because she's really more interested in EastEnders than she is in dealing with estate. So I deal with statements, and then we talk about it. But there are also benefits, and I mean benefits like personal independent payments, universal credit, etc. that come in. She works, she's really quite capable, but there are certain areas where I know it would become a complete mess if it was left up to my daughter to deal with it all. So she needs support now, as with many other aspects of her life. So I help at home in that way. But I've always resisted the idea of being a carer. I just resist it because I'm her dad.
Yeah.
So of course I care. that's my role. So I do that. So what I'm trying to do, since her mum died, is distance myself from that day-to-day running. So it's done by other people. So if something should happen to me, life goes on for her, although she'd be upset. It can continue without too much disruption to her finances, her home, etc. That's what I'm trying to achieve. So she has a company called Budget Safe, who are local, who have worked on Hannah's behalf for some years now, dealing with things like funding for her activity group that she goes with on a Friday, and things like a PA and mileage costs and so on. So they've always dealt with that, administered it, sent us advisory notes to show what's going on. So I've extended that. So one of the advisors there, her name is Paula Withers, who I know quite well now, and she's become Hannah's appointee, so deals with aspects of her finances. It's basically the benefits going into an account she's opened on Hannah's behalf, and we get a monthly statement, so everything is well organised, and it takes the pressure off me. And I know if something happened to me, that would still continue and be well managed. So what I'm trying to figure out is, there's an awful lot of information to give, and I'm a bit slow at taking it all. That's why I'm pondering it. What is the difference between having an appointee dealing with aspects of my daughter's finances and having power of attorney, somebody who is doing that? What's the difference?
So, appointee just deals with benefits, as you mentioned. An attorney will deal with all finances. Generally, appointee is, think about it, one step before court of protection deputy would come. So usually appointee is when someone hasn't got the ability to manage finances themselves. Usually, but not always, when you can't make a power of attorney. But generally, it's the first step before full court of protection deputyship is required. If the benefits being managed and that works, and that's all there is, it saves having to go through that court process. The next stage after that, if there was a larger, say, an inheritance or larger money, larger funds, I should say, and that's when the deputyship would come. So really, it's for managing benefits without having to go through full court of protection application.
Okay. Thank you.
Sorry, I don't think I was on that.
Oh, so
Sorry.
appointee would.
So yeah, I'm appointed for my son, whatever, yeah, universal credit.
Yep. So you deal with benefits.
Yeah.
Yep. And if they're the only income really, then the appointeeship covers that side of it. If there were further funds, so let's say you have benefits, but then actually there's say £50,000 in the bank account, however much, a deputyship order would then be put in place, and that would cover decisions about large payments from it. If there's more there, you need the deputyship order. The appointee is for really straightforward, what I'd say more, relatively speaking, more straightforward cases.
And how does that colour with the LTA?
Power of attorney is the equivalent of the deputyship order. So if you see the appointeeship as the more straightforward level to deal with benefits and small decisions. If there's more to be made, that's when you go to court of protection, full deputyship order, or you have the power of attorney. It's no equivalent to each other. So appointeeships, usually if someone hasn't got the ability to make a power of attorney or make decisions for themselves about financial matters, you'd have the appointeeship first, it's straightforward. If there's more to manage, that's when you go to power of attorney or deputyship route. If there's more to manage.
It's just benefits, you know, the appointee would get to deal with that.
But then-
Do.
Yeah, so I'm thinking, so then if I do an LPA and you're testing that he understands then that I can sort out a renewal, then the appointeeship is kind of irrelevant.
You wouldn't need it anymore, so you'd stop the appointeeship with the attorney instead. Or the deputy if it was a court of protection.
So effectively, if I got the LPA, then I would have to contact the benefits people and say, I'm no longer the appointee. No.
I'm the attorney now, here's the power of attorney.
Right.
And there would be, from their point of view, it really works the same
You do
way.
the same thing,
But you have a different title, and it's the power of attorney that would apply instead. You wouldn't need the appointeeship.
right, okay.
Can I just come back a little bit? My wife and I set up a trust with Mencap for this future event. So the trustees of Mencap then look after the fund.
Okay.
And all we need is an intermediary to go between the fund, requests from Hannah for funding. And that would be, at the moment, I think, all the winners at budget stage, or whoever takes their position in the future. Is there a need, do you feel, power of attorney in that situation? Or have we covered the bases?
It depends on all of the circumstances. So I couldn't give a yes or no individual circumstance, but as a general position, when there's a trust in place, you'd have the trustees who are managing the funds. If there's an attorney in place, they would be the go-between to say, because they've mentioned personal finances, they would say we need money for X, Y, Z. These are the financial needs for the year. The trustees may factor in that as part of their decision. So from the trustees' point of view, what they really need to understand is the needs of the beneficiary, the person who money is really well for. So whether that's an attorney or somebody else, they just need to understand. It's really who are they making payments to, or where's the money going. So to go into a bank account, they need to make sure it's managed. But their views really understand what the needs are.
So it can have a legal person to be the intermediary between the fund and the also would be a standard proposition.
It could be the same from the trustee's point of view. It makes things very clear.
Yeah.
Because they can say, well, here's the power attorney, this is the attorney, they're managing the account. Their due diligence, if you like, is fully covered by that. They'll be very familiar with that process.
Okay.
So legally, it's the official person to actually manage that. Particularly with larger payments, maybe